So when I think of misrepresentation, because I travel a fair bit, people always ask me, why do Canadians wear Canada Goose all the time? And I get kind of tired of the question. So I started telling people that we get one for free every time we renew our passport. And I thought that would be a way, this is sort of, I'm telling you this to look at what do we mean by misrepresentation? Because in that example, that's not misrepresentation in the contract or tort sense. Because you're not, in the tort sense, you're not doing anything carelessly. In the contract sense, you're not inducing someone into a contract. So, an important aspect of looking at misrepresentation, whether it's tort or contract, is do the facts fit the parameters of the claim? So, this is also applicable to any of the other actions we looked at, but with misrepresentation, I think sometimes it's a bit, people are sometimes mistaken as to what's going on. Some people have a difficulty looking at misrepresentation versus mistake. So misrepresentation is a specific claim in contract that basically brings into question the basis upon which consent was given to enter into the contract. So we have this definition, an unambiguous false statement of existing fact or law addressed to the claimant which induces the claimant to enter into the contract. And the two outcomes that you should know is it could be, the contract could be rescinded or there could be damages. Rescission, we looked at before. Rescission means the contract is rescinded and the plaintiff is put back in the position they were in prior to the contract. So it's kind of like tort damages, where you're trying to put the person as much as you can in the pre-accident, you think of personal injury, situation they were in. Misrepresentation also factors into our discussion of good faith. Because, especially in the common law sense, you can tell me how the civil law works in your countries, but in the common law sense, misrepresentation straddles this idea of you don't have to disclose information. But if you do, it should be accurate. But then we have sort of a subset of scenarios where if you're giving information, maybe it doesn't fit within the precise parameters of misrepresentation. So this is a difficulty. What is misrepresentation in contract and what isn't? In tort, largely misrepresentation we've seen is in a professional advice scenario. That's sort of a classic example. Those are the two Supreme Court cases we looked at that were given out in the last couple of years. The misrepresentation in tort, in contract, has many permutations to it. So usually it's some sort of verbal statement, an oral statement, and this brings into play the parole evidence rule that we looked at with contract. You remember the case of Curtis and Chemical Dry Cleaning, which is a horrible name for a dry cleaning company. Curtis had brought her wedding dress in, and the attendant gave her a ticket, and on the ticket was an exclusion clause, exclusion liability clause. And Curtis inquired into this and said, what does this mean? The clerk says, well, it only applies to beads and sequins. If we damage them, then there's no liability. In fact, chemical dry cleaning meant for it to be a complete exclusion clause for anything. And as we know, her wedding dress was stained. She was able to recover, Curtis was, because of the oral amendment to the clause at the time. So some case books will call that misrepresentation. So that would be an example of an oral misrepresentation. But that's not the only way we communicate. And the Spice Girls case shows us that conduct can constitute misrepresentation. Insofar as, how many were there? 4 or 5? I always mess this up.
I don't know, but they were good looking, that's for sure.
Okay.
They were fine.
Sorry?
They were fine.
5. Right, so one was going to leave the group and they were contracting with Aprilia. And Aprilia wanted to put their faces and so on merchandise. And they were contracting with what they thought was the full group, the 5 Spice Girls. And one was dropping out. And the Court of Appeal in this case found that the Spice Girls didn't say anything about this and had misrepresented through their conduct in going through the photo shoot, in going through the whole negotiation process and so on. And this case, I think, crystallizes the point that, and why I put it in the context of good faith, there's this hard to define boundary in the common law contract. It says there's no good faith in terms of negotiation. So prior to the contract, you don't have an obligation of good faith. As we know from Bazin, that kicks in once there is a formed contract. So it deals with performance of a contract is in good faith. And if you recall when we talked about good faith, part of the reason for the common law's hesitation towards that concept has been the criticism that good faith doesn't do anything different from what existing tools already do. The misrepresentation is one. So here, somebody is saying, well, we don't need good faith, can look at the Spice Girls case as one example and say, well, even though there's no firm obligation to disclose information, if you represent yourself either orally or through conduct in a certain way, and that's proven to be false and fits within the parameters of misrepresentation, then there is a check on contracting parties. There is an element of good faith, what might be called good faith, but in the common law, it's that we have these tools in place and we don't need this vague subject of good faith. So I think the Spice Girls case shows it's not simply a matter of, as long as I don't say anything, I'm safe. I haven't misrepresented. In fact, you can misrepresent even if you don't say anything. So the next case, Gordon and Teixeira, is sort of I think another sort of classic example. So if we amend the facts from a house that was painted to a car, if we think of, you're trying to sell a car and it's rusted, you want to hide the rust, so you paint over it. That is misrepresentation. So the point being, it's a bit more of a wider view of what constitutes a representation and therefore a misrepresentation. It's not simply a false statement. Because as we see in the Edgington versus Fitzmaurice case, which is clearly an instance of a false statement, where a company is trying to get public investment, and they say we're doing really well, but in fact, they were trying to get money in order to pay off their debts. That was a misrepresentation. So today, I think we call that a Ponzi scheme. Whether or not a statement of law is a misrepresentation is still a bit vague, and I've outlined that for you. But getting to sort of an extended discussion of what I was elaborating on with the Spice Girls case under the heading, what statements are not actionable, we have this idea of a puff. Do you remember seeing this term before?
Smoke ball?
Sorry?
Smoke ball?
Yeah. So in the Carbolic smoke ball case, Carbolic said that their advertisement was a mere puff, which means, I think in more modern language, it was meant to be to attract attention, to draw people into looking into the product, but not in itself a promise of any kind. So in a misrepresentation context, is a puff a misrepresentation? So Dimmock and Hallett, the advertisement for the auction described the property as having fertile and improvable land, and the court said, well, that is not a misrepresentation. And it reminds me, so if you've ever looked for property in different places, like really large cities, I've been renting in London, and when I first thing I noticed in London is they rent by the week, which is this crazy thing. And I asked it at an estate agent, as they're called, like, why do you charge per week? And they said, well, you pay per week. And I said, well, no, I pay each month. But you break down the price per week, and really what it comes down to is
more week than month.
yeah, so they up the price. So whatever you see in the advertisement is not actually what you pay per month, which somehow is not misrepresentation. But then you get these really sort of, let's call them elastic characterizations of the property. And the one that I thought was most hilarious was, you know, sort of, let's say, Hyde Park is a big park in London. So they'll say Hyde Park adjacent. Well, Hyde Park adjacent actually is nowhere near Hyde Park. It just sort of means you can get there. So it raises the question, you know, so when I see in Dimmock, fertile and improvable land, it reminds me of when people call a house a fixer-upper. It's a real opportunity. I've never understood that being an opportunity. I don't want to do anything to the home I'm moving into. But that's what this seemed to be. This is improvable land. And that's not misrepresentation somehow. I'm not criticizing it. What I'm saying is, Dimmock shows us that you really have to be a bit more firmly on the unambiguous side. So a false unambiguous statement directed at the claimant or plaintiff, inducing them to enter into the contract, fertile and improvable does not cross that threshold. Similarly, if we look at the next topic, mere opinions, and focus on the Bissett and Wilkinson case. Bissett and Wilkinson it comes from New Zealand but went to the Privy Council in England. And simply put, this is a case about, I forget which one is which, but let's say Wilkinson owned the property and was selling it to Bissett. And Bissett said, can you raise sheep on this land? It was farmland. And Wilkinson says, sure. So Bissett buys the property. And it turns out you can't raise sheep. I don't remember why, but. So he sues Wilkinson and says, you misrepresented. You said I could raise sheep on this land. And Wilkinson says, well, I thought you could. So the question really was, is this a misrepresentation? And the Privy Council says no. And the determining factor was, well, both Bissett and Wilkinson had no clue. They were both, neither of them were sheep farmers, so they didn't have any sort of particular expertise. So the court says, well, in that case, it was an opinion, not a misrepresentation. But then we have the Esso and Martin case, where this is a franchisee-franchisor situation. Martin purchases a franchise in England, and prior to purchasing it, the franchise is supposed to be, if we think about Toronto, it's supposed to have a direct off-ramp from the 401, let's say. But then it's rezoned, so you have to get off, in order to get to the gas station, you have to get off at the next exit and then come around to enter the gas station. So the directness of the entrance is no longer there. So Martin says to Esso, will that affect what I bring in? And Esso said no. And it turns out that it did. So what happens and why this is Esso suing Martin, Martin couldn't pay for the petrol he was getting from Esso. So they're saying, you owe us money. Esso, I think it said you'll sell about 200,000 gallons a year. And he sold much less than half of that. And here the Court of Appeals said, well, Esso is responsible because they misrepresented what Martin would have earned. And we can look at this and look at Bissett and then Martin, the two cases, which are about a century apart, not quite a century, but a good distance apart, and think, well, how do these two work together? If we're thinking about an opinion, if that's the topic, what is an opinion in the Bissett sense, and what is a misrepresentation under Martin? What do you think?
The difference seems to be the person who claims that I will do adverse opinion does he have a special knowledge? So in that way, his opinion carries a weight, like where the person relies and sees as it having objective value, something like that. Because when the opinion comes from somebody who knows something about it, so it's not an opinion, it has objective elements to facts. Like the opinion of a lawyer. It would be an opinion, but because he's a lawyer, it's carries more.
So somebody who deals in this for a living. So what the Court of Appeals said in Esso and Martin was, Esso, you are in the business of forecasting what franchises would earn. This is part of what you do. And Martin is just a franchisee. He didn't come in, I presume, he didn't come in having owned other franchises. He didn't come in with any sort of knowledge base that would be equivalent to or superior to ESO. And so, as Constantina says, sort of encapsulating it, there was an imbalance in knowledge, asymmetry in knowledge, if you want. And that seems to direct us as to the distinction between a Bissett situation and a Martin scenario, where if both parties are, for lack of a better term, equally clueless, it would be an opinion. But if one party has superior knowledge, and you can show this, it's not a matter of them being willfully blind or something like that. It's a matter of it taking ESO. If this is their business, then it's hard for them to say, well, we just gave an estimate. Somebody had their hand.
But doesn't the court decision also have something to do with whether it was a material term or not? Because in S's case, this is the subject matter of the contract. So it's crucial for Martin's business. But in Bissett, as I understand, they weren't sheep farmers, so he just asked out of interest, like, can I raise sheep here? Yeah, but he didn't even, it wasn't the purpose of buying the land.
You're sort of skipping ahead to another point here, which we'll get to, but it's worth commenting on now, since you raised the question, the idea of materiality. How material was it? And I guess the difficulty I have is, in Bissett, I have a difficulty discerning how that question wasn't material compared to the Martin scenario. We can say, well, Martin is clearly only going to sell gas. He's not asking how many chocolate bars can I sell. But still, it's not like Bissett wasn't asking out of interest, because he clearly had an intention to at least pursue that. So I'm not sure how materiality helps us distinguish between the two. Materiality is an issue, but was that, so it goes to, in that definition, a clear, unambiguous, a false, unambiguous statement, a fact that induces the other party to enter into the contract. Materiality goes into that inducement point. Was that statement a statement that induced the plaintiff to enter into the contract? And that's the difficulty I have with Bissett. I don't know we can clearly say that he didn't enter into the contract or did enter into the contract because of that. Whereas in Martin, clearly, just by the nature of the business, we know it's all about selling gas. So I think what we can more concretely take from contrasting with these two cases is the idea that an asymmetry in knowledge creates a scenario in which there could be a claim in misrepresentation under contract.
So possibly consider raising sheep is not enough for materiality?
No, what I was saying was, she was saying, Bissett only asked about it. It wasn't, and correct me if I'm wrong, it wasn't a key thing. It wasn't like gas in Esso and Martin. And what I was saying was,
We don't know.
it's not clear how material that was. But what I don't want to give the impression of is that materiality is not important. It's more within the contrast of these two cases. I think what we can more concretely say is the asymmetry or imbalance in knowledge better informs us as to how a court would look at these scenarios. So silence and non-disclosure. Keats and Cadogan is sort of the oldest case on this, that there's no duty to disclose material facts known by one party but not the other. This is where things get a bit blurry. Or not that things get blurry, but just this is a case where you have an authority for saying, well, I don't have to volunteer information. So the facts of the case, I think, are a bit difficult to maintain in a modern setting. The reason why I say that is if you're offering to rent a house and it's uninhabitable, which is basically what happened in Keats, you can't say, well, I didn't promise you a house you could live in. You know, like nobody does that. Nobody just rents land for the hell of it. So I think in a modern context, the facts are a bit problematic. But what I'm suggesting with Keats is authority for the proposition that there is no duty to disclose material facts voluntarily. And that was where I started things with the discussion of good faith. This idea that the common law has been averse to an obligation of good faith, and still is at the pre-contract stage, which is what we're talking about. And they say, well, there are tools there already, misrepresentation is one, but Keats, the principle coming from Keats, sort of gives us reason to pause. There's a distinction to be made. You don't have to volunteer information, but as we see in Davies, or I think Nathan O'Flanagan shows this well, if you do make a representation and it changes, you have to correct it. So in Witt, O'Flanagan was selling his medical practice to Witt. He said he had earnings of $2,000 per year, keeping in mind this is 1930s. But what did it drop? I think it dropped significantly, maybe 1,000, because O'Flanagan had been ill. And he had not conveyed that to Witt. So Witt purchases the practice, finds out that the practice is worth much less than what he paid, and sues, and the Court of Appeal says, yes, that was misrepresentation because O'Flanagan said it was worth X amount, and it was far off of that. The reason why I add the qualifier, far off, is I think it'd be hard to say if it was worth $2,000 and it dropped to $1,750, let's say, that would constitute misrepresentation. We have to look at something, I think, a bit more extreme. Something that goes beyond what we might call market fluctuations. And then Spice Girls is another instance. And then moving down to the heading variations on silence, non-disclosure, and the concept of half-truth, which is an oxymoron. Nottingham, Brick, and Butler. Nottingham, Brick, and Butler, I always think of, we've all met people that are kind of what in English we call smartasses. And this is sort of, the case of the smartass lawyer. Because the buyer of land asks the seller's lawyer if there are any restrictive covenants on the land. Restrictive covenants means that it affects what kind of title you get. And the solicitor thought he was being smart. He didn't know, but he said, I don't know of any. And the person buys the land, finds out that there are restrictive covenants, and sues. And the lawyer says, well, I didn't lie. And the court says, well, no, that's not enough. That was a misleading statement. It was what we sort of colloquially call a half-truth. Technically accurate, but not really what the question was about. So it was held to be misrepresentation.
So what case is that?
Nottingham Brick versus Butler under variations of silence and non-disclosure.
Page 18.
Page 18.
So again, this is sort of a variation on the idea of silence. You don't have to say anything. Well, what if you do say something and you think it's kind of innocuous? It covers everything. Misrepresentation, the courts take seriously. Then, if we move on to the heading of address to the claimant, which induces him or her into a contract, and the idea of materiality, which we've touched on already. What we mean by materiality, I think, is clearly illustrated by Horsfall versus Thomas. Thomas buys a gun from Horsfall, didn't examine it. The gun had a defect, which Horsfall tried to conceal. But Thomas didn't discover this because he hadn't inspected it, buys it, takes it home, fires it, and it explodes. And he sues Thomas, Horsfall, for misrepresentation. And the court says, well, the misrepresentation was not material to the contract, meaning Horsfall seemed to be just buying the gun. Thomas was buying the gun, but hadn't inspected it. So the court is saying, well, you clearly didn't, that was not a pivotal reason for you in buying the gun, whether it worked well. And today we would kind of say, well, that seems a bit iffy, a bit hard to say, hard to put forward. But keeping in mind this is 19th century, what the court's trying to say is, in order for it to be a misrepresentation, it has to be a reason why you entered into the contract.
But there is always a reason why you enter into the contract, right?
Yeah, but I guess a material reason. There may be secondary reasons or something. What we're looking at is materiality, and just looking at how I defined it. The misrepresentation must be material in the sense that it would have induced a reasonable person to enter into the contract. So was it an inducement? And the court is saying, well, the functionality of the gun was not an inducement for you. You never looked at it.
I mean, really, there was no representation in the first place. There's no contract or statement.
Yeah.
He seemed just like he bought the gun without any.
Yeah, and what I'm saying is, today we might be a bit more, we might scrutinize that a bit more and say, well, is it like Spice Girls? You didn't say anything, but you're saying, here, buy this gun. And implicit in that is that it functions and won't blow up when you first use it. So the distinction I'm drawing is, it's a kind of the crude core of the principle in Horsfall, that if it doesn't induce you into the contract, you can't use it as a basis of a claim of misrepresentation. So the facts we would scrutinize a bit more today. Dan?
That's the question for you. So how does the material representation plays along with the principle of caveat emptor? Like you can be materially induced based on the full statement,
Yeah.
which is unambiguous, but you still have a duty to be aware of any faults or defects of the services or goods you're buying.
The way I put it is that caveat emptor and misrepresentation sort of sit side by side. if you want to visualize it. And misrepresentation is the side that goes too far. And we can ask the question, well, why does it go to misrepresentation and not sit within caveat emptor? And this is kind of what we're looking at. If we go back to Bissett, Bissett is trying to say you misrepresented, but basically it would fall into caveat emptor in that case. So this is the line that we're looking at. How do we distinguish between those two? What I'm saying is, here are, through the common law cases that we're exploring, here are some guidelines or signposts as to what falls into misrepresentation and what might, to a layperson, be called caveat emptor, buyer beware, if that makes sense. Or is
is there a defense of contributory negligence?
in what sense?
In what sense? Well, let's assume plaintiff had a duty to inspect for himself, because that's caveat emptor principle. And if he was induced by some additional things that were untrue, wouldn't there be some kind of a set-off between, failure on both ends in terms of damages or rescission of the contract?
Well, I think, so if we look at red, grade, and herd under the reliance topic, because I think it's germane to the question. Red, grade hadn't inspected the documents, and the court said that relying on the oral representation was enough. There was no duty to examine the papers. The question will come down to what are the particularities of the facts. So was there a representation to some effect that induced the party?
I'm a bit lost. I understand the warranty. That's kind of okay. But this is out of the contract and all of a sudden is getting into the bone of the contract.
What do you mean by getting into it?
Into the bone of the contract, because if someone didn't follow his or her own duty to protect himself or herself in contractual relation, no matter how naive that person can be following unambiguous false statements, how all of a sudden there is a reason to resign that contract, let alone get damages?
Well, I think it goes back to where we started with contract, the importance that the common law courts place on formation. And if there is, let's call it defective formation, here consent was given on a basis that was false, or a premise that was false, the courts will say, well, no, we're not, that's not a bargain that we would allow to be enforced. So in red, grave, and herd, what I'm pointing out is, I think the courts will look at, even if red, grave was silly in not looking further or doing what we might call today is due diligence, the preceding question would be, well, did herd do something to induce red, grave, or anyone to enter into the contract? And the importance is placed on that. And secondary to it would be any sort of failure on the part of a plaintiff. But keep in mind, in red, grave, the court said there was no obligation on red, grave to look further. The representation was there. It seems similar to Whiff and O'Flanagan, the medical practice, right? So O'Flanagan says, I earned $2,000. 5 months later, they complete the transaction. Whiff then finds out that the practice has been making substantially less. And the courts are saying, well, if you relied on that statement, and that was material to why you entered into the contract, then you have a basis for a claim of misrepresentation. So what the courts are doing is making a decision, drawing a line we may not all agree with where they're drawing the line. But what they're saying is, the line is drawn when the other party does something to induce the plaintiff into the contract. And the importance is placed on that, and then they would look at if it's necessary or if there's an obligation that the plaintiff should have done something. So it wouldn't be contributory negligence, but there could be a reduction in damages
That's it.
if there is damages. But let's say, taking your example, we focus on rescission. What the court is saying is, we want people to use the mechanism of the contract, but we are not going to allow people to act in improper ways. And what is improper? Well, to misrepresent. That being a false, unambiguous statement meant to induce the plaintiff into the contract. So if you lie to the person, the courts are saying, we're not going to uphold that lie. That's what they're placing the emphasis on. Even if we might criticize the plaintiff's conduct, they were kind of lazy or whatever, the importance for the courts is placed on the actions of the defendant, as it is in the cases. Tenesh?
I get your last point, but is there any duty or level of duty on the plaintiff to verify the authenticity of the representation?
What do you mean by the authenticity? Like,
Someone tells me something.
yeah.
And I just accept it, or is there a level of duty where I should look into that representation?
Yeah.
That's what I'm asking.
I say,
Especially if it's a material matter
yeah,
concerning.
the way we look at it now, I would say, the courts make this distinction. I think your contract assignments are putting you in this situation. Courts make this distinction between who are the parties. If it's a consumer or an individual, they may be more relaxed, let's say. But if it's a commercial party, they will presume sophistication and say, well, you should have taken your due diligence. So to illustrate the point, just because it was a case we talked about, there was in tort, Caparo and Dickman. In Caparo, the shareholder had a duty owed to it, but Caparo, as a potential purchaser of the company, that was beyond the purpose. They should have done their own due diligence before they went in and purchased the company. So I think that's the dividing line that courts will take on. Yeah.
A question about how to reconcile these two cases, the
How to-
Gray
sorry.
and
Sorry, I
the hospital, and the two cases we just
Yeah.
discussed, the hospital and the Red Gray.
Yeah.
I'm difficult is because actually the Thomas in the first case is as Gulliver as Hurt in the second case. They both just blind reliance on the other party's representation, but the decision are totally different. So in the first case, it's also kind of because it's a concealment of the defect of the gun. So it's based on the Spicy Girl case, should be also a
Yeah.
misrepresentation.
See, I think, and this is what I was explaining before, I think the court is trying to be a bit more, is trying to convey the principle that if it didn't induce you, you can't rely upon it. And they're going about it in kind of a crude way, a way that we wouldn't necessarily look at today, but at the time, I think it fits really to the time, where they're saying, well, Thomas, Thomas, you didn't even inspect the gun. You can't now come to us and say it was a misrepresentation. You didn't take your own proper care, let's say. So how material could it be? So the principle, I think, is what we take from it. You have to show, if you want to think of it this way, sort of a causation, a connection between the two. Did the representation induce them? And I think the court in Horsfall is saying, well, there was no representation. Basically, Horsfall just says, here's the gun. Whereas in Redgrave, there was a representation.
You see, but based on the previous case, the case that there's painting over the dried rocks,
Yeah.
then the court said that it's kind of, because it's a misrepresentation by conduct, it's not oral or verbal, but it's by conduct.
Yeah, so remember we talked about in tort affirmative duties of action, and I explained the concept of you have no duty to do something, but if you do, that's when things get problematic. This is the same distinction they're making here. If you do something, then you can be, that can put you in a position of liability. So whether you paint over rust or you orally represent, if either of them are false, that is a false, unambiguous statement meant to induce. That's what they're focusing on.
So even in the Horsfall case, even the Horsfall means the seller of the gun concealed the defeat by inserting a metal that
Yeah.
it's not the same thing as maybe paint something over the defect part of it.
Yeah, that's the thing that I'm saying is a bit problematic with the case, and why I think the court is sort of to the detriment of clarity, when I say, at least in a revisionist sense, focusing on if it wasn't a material to why you bought the gun, that's what we're going to focus on. But in the other cases we've seen, there was this positive act, and your point is, well, isn't inserting something a positive act? And I think that's fair to say. That's what I'm saying here. If we look at Horsfall today, I don't know if it would be the same decision now as it was then. And so what do we take from Horsfall? What I'm saying is we take from Horsfall that it illustrates the point or principle that the inducement has to be material. So if you buy a car and it's red, but you don't care about the color, you care about the car itself, you can't then turn around and say, well, I didn't want a red car. That wasn't material at the time. And as I say, to the detriment of clarity in Horsfall, the court is focusing on that one aspect. Ebra, and then I'll come back. And did you have this?
Yeah, I just want to ask, like, a scenario based on Horsfall.
Right.
Like, if I go to a store to buy something, okay, I found it on the shelf and I took it, I buy it, okay, and I went home and it's not working. Can I enter the store? They have like a policy, there's no return or exchange or whatever.
Mm-hmm.
So they refuse it to return it.
Right.
Can I claim like misrepresentation in that case? Or there's no inducement?
See, the problem is that you're sort of in the modern context. In the modern context, we have consumer protection legislation that would likely give you something more. Misrepresentation would maybe be like a third argument that you put forward. It wouldn't be the strongest, but would likely be some sort of retailer obligation under consumer protection. So, could you make a misrepresentation argument? Yes. But I think it would be a more difficult argument than the framework of was it in Ontario, the Consumer Protection Act?
Yeah, because I checked the Consumer Act and they said like once it's written on the receipt that
Yes.
they have like a policy in place.
Yeah.
In that case, they are not like obliged to return that object.
So what might I've seen this done, and maybe this would be what was done, they'll give you a store credit. I think it would be it seems as though it'd be more exceptional that they say you get nothing. Sorry?
Dollar Amatasca.
Who does?
Oh,
dollar.
like dollar store.
Okay, well, I think that would go to Dayon's point, caveat emptor.
I thought you were talking about poisons.
No. So, like, I think if you're going to the dollar store. Sorry, he was first and then I'll come back.
I was just going to say, I mean, I think the points have been made by you and by Diane already, that one has to assume that when somebody wants to buy something, that they want to buy something that works. So, kind of at the heart of materiality, to anybody I would have thought, is that one has a functioning product. So I think there's something kind of inherently fallacious with the reasoning of the court.
In Horsfall.
Yes, I
Yeah.
don't know what level of court this is, whether it says England or
Yeah.
CR. So I guess my question really is, if I'm answering an exam question or if I'm writing a factum or whatever,
Yeah.
I mean, would this really be a reliable kind of case?
But that's what I was saying, so maybe to be more explicit, Horsfall would go to the principle of an inducement has to be material.
Yes, I hear, but I think I hear, so that's really the only point about it, because the reasoning of the court is wrong.
I think we, as has been elaborated on, there are some gaps in the reasoning, especially when we look at it in a modern context. But the point, because this case is cited in all the textbooks, so I feel like I can chop it out, even though there are problems. So if you read any textbook, my concern is you wonder, well, why isn't this here? So it's cited for that discrete proposition that it has to be material.
And as I say,
I understand.
you assume it has to, material, a working product is material to anybody, I mean.
Yeah, but like, I think that was the difficulty we had, I forget the name of the case, but where the property was sold and the house was dilapidated. As I said, nobody rents land just for the hell of it. Yeah.
Is another potential interpretation that, and I asked the question on Monday, if you have the opportunity to inspect and you don't take it up, it means that you don't actually care what the place looks like or the product looks like or whatever the case may be. So contrary to the dollar store purchase, it's not really relevant to you. You prepare, or is the court saying?
I think that was Dayon's point, or one of the points that he
It was my question.
And what I was saying was, that given the cases, you can't just make that assumption, because the primary question the court looks at is, was there a positive act inducing someone in a material manner? And then they might look at, well, did the plaintiff fail to do something? But the primary question that they put forward, based on the cases, is, was there a material inducement? Now, if we put it in a different way, which maybe is what you're looking at, we look at an exam, and you have that kind of scenario, then you have two viable, arguably, competing arguments. You have one where certainly the defendant did something wrong, but the plaintiff wasn't necessarily all clear, let's say. So there are ways, there are competing arguments to say, and what I think we have with the cases is, we have authorities for both sides of the argument. Zita and then Sparta.
Actually, I just wanted to ask if I'm saying, but I think to answer, in summary, I say that there must be an inducement and it has to be material. That's the issue, but basically you just.
Yeah, so materiality and reliance goes to what we mean by inducement in that definition I gave you at the start.
But it should be objective standard. Right?
Yeah, no, always objective, yeah.
Always
So-
a reasonable.
Yeah.
Yeah.
So it's not a matter of the plaintiff saying, well, it induced me. It has to be, I've read that from one of the cases, it has to be the reasonable person.
And some people are silly, they have incredibly, strange.
I see them every time I drive in Toronto.
I see one in the mirror in the morning. Every day.
Sparta.
I think in here, what the court did is because the fact that you're buying a gun, the fact that you're buying a gun, that doesn't necessarily mean that you're going to use it. You might put it in your cabinet in there, and.
I say that depending, so are we in the US?
So, and it might be in there for forever, for centuries, and
Yeah.
nobody's gonna use that gun. So, the
Yeah.
fact that he didn't inquire as to, like, what was he going to do with the gun, he just
Yeah.
took it.
It could have been an antique.
It could have been an antique, and then he goes home and decides, let's see if it goes or not, and
Yeah.
something happened. So the contract was formed, and during the formation of the contract, there wasn't any misrepresentation as far as court is concerned.
Yeah.
So what happens with the gun afterward, that is something else. Like,
Yeah.
it was effective or not, but it's.
And I think between the last couple of questions we've had, we have an illustration of the competing arguments in the scenario. And as I said, for the purposes of an exam, and as I explained before, why I situated within this context of somebody first coming to you, not when you go to court, is they're asking you, do I have a claim? And what we're working on is how do you assess that in a quick manner? How do you give your initial opinion? What are the considerations?
I'm just wondering, it's a very weak argument, no?
Which one, sorry?
That the plaintiff was not clear by not checking.
Depends on the facts. Like, I think if we use the horsefall facts, I think they've illustrated that there are competing arguments.
Yeah, but that way before consumer protection and before, yeah.
Sure.
Because even if it's not a consumer protection case, the principle still, it's already in the system.
Yeah,
The
but as we...
principle that you are not supposed to cheat the other party just simply because he's not checking. It's already
Right.
in the system, even if it's not exactly a case where the regulation applies.
Yeah, but the difficulty, as we see in the common law, is it is highly fact dependent. And so our role is almost contingent on a client by client basis. How do these facts apply to the law? And what I've been trying to work on with you is getting a sense of the law that you can put things together in a relatively quick manner to identify the issues and then chart a general path of how to address it. And because then, if you take the case, obviously you should have time to prepare. You get into more detail. But at that first stage of handling the query and then the law, that's what we're looking at. I thought there was another hand, so I apologize for that first. Yeah.
Just I want to ask a follow-up question, is that if whether the reliance or the materiality is going to be assessed on an objective basis, then whatever the recipient of the representation take the chance to inspect or not should be irrelevant. Is my understanding correct? Because you will assess whether it's material on an objective basis.
Yeah.
So whether the recipient of the information took any action to inspect this is irrelevant as to whether it's material or not.
It can be. Like, I think, because this is where I believe Dayon's question is. If you have a fool, what I think Dayon's going to be, you can't be saved by the fact that there's no obligation to look into things. That's not what's happening.
But
So I'm hesitant to say, in an absolute manner, no matter what the guy does, it's okay. That's not what the law is saying.
okay, so if you take the silly person to cheat, it doesn't matter that because he's silly, then he should be blamed because he didn't take a chance to verify.
Yeah, so that's why we have sort of the horsefall and red grade. I see them as sort of bookends to this. It has to be material. If you don't do anything to show that it's material, you're basically giving an argument to the defendant to say, well, materiality is an issue here. There is no materiality. It goes to your point, I think. So it's hard to say, maybe in like a civil law context, here's the rule. It's much more relative in misrepresentation.
On which basis the contract is decided if material misrepresentation is found?
On what basis?
Yeah.
That it was entered into under false pretenses. So the consent was invalid because consent was given on, let's say, these three reasons, and point number 3 was false.
Well, it goes back to parole evidence. If the contract is the contract, whatever preliminary was discussed prior to the contract
Yeah.
is irrelevant.
But misrepresentation brings in that area that we talked about in relation to parole evidence. When does parole evidence come into play? It's when the contract is not entirely written. So these are all situations where there's some sort of oral or conduct representation that the plaintiff is saying, well, I relied on that. Or that was an important factor in why I entered into the contract. It's not after the fact, it was a written contract and you're trying to get out of it. It's that this was sort of a mixed formation of contract scenario.
From the concept perspective, we cannot prove that there was any misrepresentation in this case because the court will ask questions, let's say the court will ask questions as to what did this defendant do? And basically the defendant didn't do anything. He just went, picked it up, went home and do it. So where was the misrepresentation by the defendant?
Yeah, but as
So-
in Horsefall, as we talked about a few minutes ago, you could say there was a positive act in the inserting of something to make it look like it's workable. So let's say, I don't know guns really, but like the cocking device, you put something in to make it look like there's one. Arguably that is an act, similar to what we saw with painting over rust. So that's where we get into the difficulty on a factual basis. And that's why I'm saying, in Horsefall, I think at the expense of clarity, the court has focused on the one principle of materiality. Or maybe the guy didn't have a good word. So before we take the break, I wanted to give some time for any questions for the hell is it? The contract assignment. I assume you haven't started before. And if you did, I don't think anybody wants to admit it. So were there any questions about the assignment? If there are issues with needing an extension, the way Osgood operates is that all goes through either Luke or Michael. They don't give us any authority.
Do we need table of authorities?
I think the footnoting is fine. and like get used to using the McGill guide. To me, there are more important things in life than citations. But when you submit a factum to the court, if you have the improper citation method, it doesn't look good. So I'm mostly concerned with the quality of your arguments, but take it as an opportunity to practice the citation method. Sorry, yeah.
So I know you, I know you wouldn't want repetition. That is, I know you said minimum 3,000,
Yeah,
maximum 8,000.
yeah.
And looking at the assignments, it seems, you know, it's a pretty new area, and there is not much material.
There's a fair bit of material.
A fair bit of material, yeah, but then, like from what I've gathered, it's mostly scholars' argument on that concept.
Yeah.
Yes.
I would say that there are a number of cases still, but the question posed is along the lines of, if we take Heller versus Uber versus Heller, or Heller versus Uber as an example, is the court expanding what's happening with unconscionability? So what does that entail? Well, what's in your opinion, the core of unconscionability? What are the elements of unconscionability? What do the cases tell us about the threshold of what is unconscionable? And you go from there. So I understand your point about it being a new area. I would say this isn't necessarily a new area. The question really is,
evolving area.
sorry?
Evolving area, changing.
Yeah. And is there scope for this kind of interpretation using the core of unconscionability? Just as we saw with the Supreme Court in Bazin. Cromwell says, well, I'm not doing anything new here. Good faith is a core of contract law anyway. Here are certain points, but I'm going to say this is a general organizing principle with a sub-point of honesty. So this, really simply put, this is where you can make your money in terms of a career. Coming up with these novel arguments, coming up with being at the forefront or the crest of the wave. So that's what I'm looking at. But there are cases, there are certainly journal articles and so on, but there are cases that can be explored. Yeah.
What about the small entities? That's the part that is a bit.
So I sent you an email,
Yes.
and so I'm not trying to advertise myself, I swear. Just, I thought the blog post would give you links to some definitions. So small to medium-sized enterprises, if we look at the EU definition as one example, it's entities that have 1 to 250 employees. And arguably that's a huge variation, because a company that has 5 employees and a company that has 200 functions differently. So within that, you may say, well, I don't think that this is, the 250 is really what Uber and Heller is about. It's more about the small, what might be called a micro industry.
But do we need to cite similar cases?
You don't have to. Like, I don't know if there are necessarily similar cases on that point. What I found in commercial law in general is that there's a homogeneous sense or idea of a business or a commercial entity. And that is that once you cross this threshold from employee to commercial entity, you're presumed or imbued with a certain level of knowledge, which I don't think is necessarily accurate. I think it's viable to question, and I think the Heller case is raising that question.
I mean, I know you sort of positioned it in the context of the Uber case, and you sort of asked about small business enterprises.
Yes.
But, I mean, are you asked, can one deal with it rather on the basis that it's a more general... Can one deal with it on the basis that it's a more general question of whether or not...
Sure.
Because it's really it shouldn't really matter whether it's a kind of listed company or a small business.
I push back on that because I think it goes to the first question about what is unconscionability. And at its core, unconscionability seems to be concerned about an imbalance of some kind. So I would say a listed company would be very different from a small business in terms of imbalance. Or at least the argument is available there in terms of unconscionability. One could better fit than the other. So that's why I pushed back on that.
But that sort of seems to suggest an economic imbalance, I guess.
But is that not part of it? Like if you look at, I think the English cases, for example, elaborate a bit more on this than the Canadian because they deal with sort of what we'll call capacity issues. If you're an elderly old woman that doesn't know better, unconscionability is the argument for you. But Heller seems to be focusing a bit more on commercial applicability. And I'm not sure, my guess would be, I think you would feel maybe that's too far, and that's fine to put forward.
No, actually what I suggest is that the SEC should kind of use this opportunity to clarify its position on unconscionability, kind of along various different, or rather across various issues like who can raise it, when can they raise it.
I'm hopeful but not optimistic.
Yeah. In other words, not just around who can raise it, but whether it can be raised by anybody, essentially, if the circumstances dictate that.
Yeah.
Because we've already got economic duress or whatever the phrase is for...
Yeah, but keep in mind though, that these actions are actually, they may come from a common place of an imbalance, but they're sort of scalpels, if you will, with the metaphor. They're more precise, like economic duress really is different from unconscionability. Because in economic duress, as we know, you have to have a situation where basically the other party is threatening not to perform their obligation unless the other side pays more, does something like in the NAV case.
So you mean, in other words, in the course of the contract already rather than pre-contractually in this case?
Right. But then the further wrinkle to the Heller case is, I think, so unconscionability basically has been treated largely as a matter that vitiates the contract, rescinds it.
Yes.
But in Heller, they're not doing that. The Court of Appeal is saying we can sever this forum jurisdiction / dispute resolution clause, which is different generally, although not out of the realm, because we know that the courts are okay with severing problematic provisions in favor of preserving the overall bargain.
That's for kind of specific exclusion clauses.
Yeah, so there's a question there.
Look, I mean, so just my last point, sorry, but I guess I'm critical of the decision. I didn't know to what extent you wanted us to analyze. I've spent a little bit of time kind of analyzing the decision because I think it doesn't really help the cause much. That's really my argument. It's kind of conceptually pretty woolly, actually. So it doesn't really advance the... I mean, it's a nice principle to take, and we all agree, effectively these are consumers. They're no different a position as household consumers, these drivers.
Right.
And we accept that. That's kind of stating the obvious. But the court's a bit lazy, you know, in its kind of assessment of unconscionability, and so for me the contribution is pretty limited. And it could be that it wasn't the main thrust of the decision ultimately, you know, the main thrust was probably the definition of the employees.
But no, it wasn't. That was actually not what they were doing.
No, sorry, the ESA, whether they could, I thought.
Yeah, but they weren't determining that issue.
But what is there is a primary issue on the ESA in this decision?
There's an issue on whether or not Uber drivers are employees or independent contractors. That was not something that they were dealing with though. The court, reading through the decision, was saying, we'll accept that they fall under the Employment Standards Act, because this is a preliminary motion about whether or not unconscionability or the unconscionability argument can excise the dispute resolution clause.
Look, I stand corrected, but I thought the bulk of the case was dedicated to determining whether the ESA applies.
No.
Even if they determine that matter, the case in that notion, it's not related to unconscionability anymore, because it's like contracting out of the employment act standard.
Yeah, so one way to look at it is basically, as Ibra says, let's assume that they are commercial entities. Can they argue unconscionability on this point? That would be independent of them being employees. Because arguably, if they were employees, that clause is out. Like, you know, you don't have laws saying, well, if you have a problem with the hours I give you, well, let's all jet over to Amsterdam and resolve this. You know?
Well, I'm kind of shocked. That would be the first employment ever where you can check in and check out whenever you want.
Well, but there's an
That would
intermediate.
be like the first employment with no structure, no manager, no supervisor, no required time. And as a matter of fact, you can quit and come back in a month or a year, for as long as you register again on the...
Yeah, it's not quite that way. And as somebody who talks a lot about this topic, I can say it's not that simple.
Okay.
Ebra, did you have your hand up?
No, just a comment.
Balcony.
I was just going to say, coming back to Wallman, where the court pretty much did stipulate that the decision in terms of conscionability is separate and independent. And I think when you look at it in context too, it's pretty evident why, because the multiple tests they use, whether it comes from like the decisions out of the BC jurisdiction or Ontario jurisdiction, it doesn't really discriminate. It doesn't really distinguish or discriminate when it comes to like your employability and whether you're an independent contractor or if you're an employee. I think what they look more when you look at the examples, like the tests that apply to Titus or even the ones that come out of the various BC cases, they just basically take a look at like pretty much if there's on unequal footing and basically your knowledge and your experience. So in context of whether or not you're an independent contractor or employee, it doesn't really matter. I think where it does come in is just basically to take a look at the knowledge and whether or not you have that equal footing.
Yeah. That, like, I can't really say anything more than that's viable, just because it goes into some of the, just like the question before, like everything said is fine. It, you know, it gets into more detail than I can really say, well, I wouldn't do that or I wouldn't do this. What I push back on, which is the one point, I wouldn't treat listed companies like an Uber driver. I think there is a real viable distinction there that comes through in Heller that should be kept in mind. Yeah.
I have some difficult time thinking about why there should not be a doctrine of unconscionability in the context of commercial context.
Okay.
Yeah, I noticed that actually the Canada court has already applied this principle in commercial settings like the Hunter engineering and also this Turcon case but it's applied to the exclusion clauses.
Right, but it sort of adopts the sort of capacity understanding of unconscionability was my thought on it. If we take Turcon, And remember that test, the first question is, does the exclusion clause apply? And then we look at either 2 or 3. 2 being, is it unconscionable? 3 being public policy.
So means that my understanding is that there's no hurdle or no any barrier to apply for the court to apply the doctrine of unconscionability. And also on top of this, my understanding is that the court always, the Supreme Court always, the jurisdiction of the equity means that the court can do in the specific circumstance, the court can do whatever it considers fit to do justice. So, so what are the hardship? I have hard time to understand why. What can, if I want to argue against this principle, what are the...
Against unconscionability applying to commercial parties?
Yeah, if I want to argue against this principle, how should?
I guess my answer would be I look forward to your essay.
I have all reasons to argue for it, but don't have reasons to argue against it. It means I have a lot of reasons to argue for it.
Right.
But don't have reason to argue against it, so I feel...
Okay, well,
sure.
You let me know where to look in your essay. Did you have a question?
Yeah, just looking back at Keller, it seems to me that it's a beautiful essay on unconscionability. But at the end of the day, was really the decision on unconscionability when the clauses were excised? Because they dealt specifically with the forum of the matter, the forum selection, and also the jurisdiction of the law that matters. Did the court really need to look at unconscionability to decide those 2 factors? There are cases which deal with those factors be outside of unconscionability.
Yeah, well, so just for clarity, I think, and correct me if I'm wrong, I think Tamesh is referring to this could have been argued under a topic called conflict of laws.
Correct.
And some may say, well, this should have been a conflict of laws case as opposed to a contract case. Fair enough, but the court took it down the contract route. And I guess for clarity's sake, I can say the court took aim at this provision through contract, it seems, because they said this was an exceptional clause. And why they called it exceptional, I believe, is this wasn't just a dispute resolution clause. It was a dispute resolution slash jurisdiction clause. So it went further than the court was at least comfortable with. So that's why I think they dealt with it on the contract argument as opposed to a conflict of laws issue. So to be clear, you don't have to look at conflict of laws, don't have to read conflict of laws for the paper, you just focus on the contract aspect. So I think they did it, as I said, because they focused on the provision itself and said, this is just extraordinary. And because of its extraordinary nature, one being a dispute resolution clause tied in with a forum selection clause for a guy that earns between $400 and $600 a week. He has to go to Amsterdam. Might as well get high because the case isn't going to go well.
Would the forum selection clause be covered on the Tarkan exclusion clause? Or is it a separate category you're speaking of here?
Why would you think it would be?
No, I'm just asking the question. To have your views in there.
It gets into a bit more detail than I want, but I will address it because I don't want people to sort of go down a different path. I think the difficulty with treating this through Turcon or as an exclusion clause is those comments are aimed, Turcon is aimed at or is a case within a broader context of the overall skepticism of courts over a long period of time towards exclusion clauses. So I forget the case name, but I gave you a quotation from Chief Justice Laskin when we started exclusion clauses saying, basically, if you're going to exclude everything, why have the contract? There has to be something at its core. Now, maybe the argument can be made by analogy that this type of clause should be scrutinized just like an exclusion clause. But I think if you go down that route, you spend a lot of time trying to say why this clause is like an exclusion clause. I don't know if that gets you so far or where you'd want to go. It'd be interesting to explore, but given the time constraints, I'm not sure that would be, let's say, the most efficient use of time. I'm not sure how much value it would add. Honestly, like, I'm not sure. I'm not speaking in coded language. I'm not sure. And I don't want people, since it's due in a couple of weeks, isn't it?
Yeah.
I don't want people to spend the time and find out it isn't valuable and then have a problem. That's my sole concern is on that.
You see, my concern is, if it doesn't fall under the exclusion clause, then Heller has advanced the law significantly.
Okay.
And therefore it's something that matters.
Yeah, but like, but can't we say that, like, if we look at it as I put in the question, if we look at it as an unconscionability question, and your assessment is it advances unconscionability significantly or purports to,
Yeah.
and then you give whatever characterization of that, positive or negative or in the middle, that's fine. I don't think going through the exclusion clause route I'm concerned that it would take you off track. And as I say, given the time, I don't want people to be going down a different route that they may find wasn't as useful. That's my only concern. It's not a pronouncement on the idea or anything. It's an interesting idea. But it would just, I think, take a bit more time than people may have. Because I'm assuming everybody works during the day and you start new courses and so on. That's where the factors in what I'm saying. So,
Don't overthink.
sorry? Oh.
Don't overthink.
So it's 7:45, come back at 5 after 8, and we'll pick up with, on the topic of misrepresentation, something very weird happens in first year law in Canada. In the first week, everybody says, I'm going to be the first. I'm going to be the first place student, I'm going to get an A. And I don't know if you know, but in Canada, all the grading is done to an average. So you've heard of a bell curve? Mm-hmm. So in Canadian law schools, we have a B average. Your program doesn't have this. So it means the instructor has to keep everything to a B. Meaning some get C, some get A. But after all the exam results are given back, magically everybody you talk to has an A. And it's this Christmas time revelation that everybody's going to work on Bay State. Everybody's a genius, but somehow you still have a B average. It wasn't me.
That's really depressing when you learn that you suck.
I think, I think I saw it in my first degree. I've seen some people really struggle. I have such sympathy with them, and I'm not trying to say I'm better or anything like that. It's just, if you're facing something you're ill-equipped to face, I can't imagine the personal toll that could take. That, as you say, must be very, very difficult to confront.
Especially around Christmas time.
Yeah, well, you don't get your marks back till January. So you get to be happy over the holidays and then contemplate another career come January.
Snow blowing is,
Sorry?
snow blowing is really at a high piece at that time.
Yeah. So, Dayon asked a good question that I thought should be dealt with the group, the essay, and that was, do I look for a certain format with the essay? And he asked particularly with the introduction, how should we do the introduction?
In other words, do require the paper being written for someone who is completely a lay person, or it can be like done by skipping that kind of introductory step and just.
I'm fine with getting into it, so to speak. So I don't think you have to, for example, in the contract case or in the tort case, you don't have to tell me about Heller or Jones. You can talk about the facts as they direct your argument, but you don't need to just summarize things. You can guess. That's what I mean by getting into the arguments. So in your introduction, you're outlining what it is that you're going to be doing, what it is that your argument will be, and you're sort of flagging your key points in your introductory paragraphs. So I don't have a personal preference in terms of format beyond that. You know, some people worry about first person or third person. I'm an I don't care person. So whatever format you want beyond that, it really is, I'm much more interested in the quality of the arguments and how you support them than the format. If there are certain things that you want to work on, like a formal legal writing, and this would be an opportunity to do that, but I'm not requiring you to do that. That is clear. If, you can single space if you want, but I'm going to read them all online. So by the time they come in, I don't think I'm in the country. So that's why I do everything on Moodle. And it saves paper while I'm emitting carbon with all the flights I take. I think there's an offset there somewhere.
The royal family apparently buys offsets via the celebrity friends Elton John and Co.
Yeah, well, actually, if you fly BA, you can buy offsetting. I don't know where BA puts that money, but apparently you can buy your offsets.
I think they're a little bit higher if you fly by private jet.
I would like to be able to tell you. I'll let you know when I've had a comparator opportunity. So pre-contractual misrepresentation. What we're looking at here with Queen and Cognos kind of overlaps with the tort misrepresentation a bit, but is dealt with in the contract textbooks. So Queen and Cognos, just to be clear, this isn't R versus Cognos. The guy's name actually was Queen, so it's not the government. So Queen went for a job interview. They told him he had a job. He quit his other job. And then the defendant says, remember that job we offered you? Turns out it's not going to happen. So he sues. And he uses the Headley-Byrne tort, negligent misrepresentation. And the Supreme Court, Yakabuchi, says Headley is part of Canadian law, but is Headley liability limited to professionals who are in the business of giving advice? He says no. So remember, we talked about negligent misrepresentation being largely about negligent advice given in a professional context. Yakabuchi with Queen is saying that's not the only instance that negligent misrepresentation can be used in. It can be used in this setting the Queen and Cognizance setting. And then, in good Canadian fashion, he sets out a test. Unfortunately, he departs from the 3-part nature of Canadian tests and gives us a 5-part test that I've outlined. There must be a duty of care based on a special relationship. The representation in question must be untrue, inaccurate, or misleading. The representative must have acted negligently in making the misrepresentation. Misrepresentee must have relied on it in a reasonable manner, and the reliance must have been detrimental to the misrepresentee. So, in terms of a pre-contractual misrepresentation, in this case where you have sort of this tort contract overlap, which is what is happening here, this is the test you use. So it's different from what we've been talking about with misrepresentation and contract, where there's been a false unambiguous statement to the plaintiff, inducing them to enter into the contract. Here, this is a more precise situation, whether or not the defendant has, a duty of care in some way. So in this employment type setting, the court is saying there was a duty of care owed, and they sort of draw in the 3-part test from Hedley-Berg. And then we see it applied in Aug21. And there aren't many cases that have applied Queen and Cognizance. And of them, very few are at the appellate level. So this is sort of a unique opportunity where the court applies the criteria. Now, just for reasons of time, and because I want to get on to concurrent liability and tort, I'm just going to leave that there and go to concurrent liability so that we start off next week with thinking through the overlap. And as I said before, I took out the damages class in order to give us an extra class to sort of put things together and talk about review and so on. So really, what I look at next week is review in different ways. So Monday, we'll put things together, especially with the overlap that we've been looking at, but get into contract and tort. Then on the Wednesday, we can look at last year's exam and go through that. Yeah.
Isn't it difficult to know when we have the facts when do we apply pre-contractual misrepresentation test and the other definition? Like if this type of misrepresentation we have, is it on the contract or pre-contract?
Well, the Queen didn't have a contract.
Yeah. The difference is there was no contract technically formed in both of these cases. So it's sort of a misnomer that enabled it, pre-contractual.
So there is no contract?
No. Whereas with misrepresentation, we have a contract formed, what we've been talking about. Contract has been formed, and it's been formed under false pretenses.
So when you have a contract, we never apply this test?
Unless it is within this kind of specific scenario. So, looking at Queen and Cognos, he's looking to enter into an employment contract in all his optics. If they're looking into, we'll loosely call it a commercial contract, but no contract is subsequently formed. But the question is, has the plaintiff been misled or misled by misrepresentations? So it's kind of a discrete scenario where we have this pseudo-contract setting that never quite materialized, and we're looking at the tort, so we're we're combining the two in maybe an unhealthy way or confusing way, but nonetheless they're being combined. So the overlap, simply put, and I said this before, you can sue in contract and tort concurrently. You cannot recover in both contract and tort for the same claim. So what that means is, I used the phrase before, when you submit a statement of claim, which is your outline of your legal arguments when you're suing someone, assuming you're the plaintiff, you can say, I'm suing them in both contract and tort, and here's why. But the court will not give you damages in contract and tort. They will only give you damages in one. If you recall, I asked you which one would likely be better, and usually it's the tort damages, because contract damages, if the contract is drafted well, are usually capped at a certain amount, and the tort damages usually provide the plaintiff with a more complete remedy. So that's concurrent liability in a summary manner. Now we'll just go through the cases.
And this is for the judge, the judge will decide which remedy?
No, then the plaintiff will have to choose. So that's why I said which will be better. So if you have the luxury of choice, which is rare in itself, because it means you've been able to successfully show both a breach of contract and breach of a duty of care or negligence, then which one do you choose? But, and maybe I wasn't clear enough, you sue in both at the beginning in the statement of claim, because you do not know at the start all that you will know if it goes to trial. Yeah.
Do you actually frame the claim in the alternative, or do you actually file them both?
I think you can file in both, if I remember correctly. So, pursuant to BG Checo, you can sue in both, but you can have an alternative, like I sue you in negligence. In the alternative, I'll sue you in an intentional tort. But BG Checo shows that there was a suit in both. So we'll just work our way to that. The old rule was you couldn't do this. So looking at BG Checo, factually what happened in BG Checo? How do you understand the issue that arose?
Was the exclusion clause, which we can see in the case, right? Some sort of exclusion.
It's a bit of a curious case when we look at it in terms of the tort and contract overlap. So BG Checo had a contract with BC Hydro, and I forget what it was they were going to do. They were going to do some work. Sorry?
Erecting towers.
That's right, thank you. Towers for power lines. And so BG Checo only gave an estimate or put in the costs that they would charge for that based upon the area in which they would put the towers in being cleared of trees. So if you think of a forested area, BC Hydro wants towers for hydro lines to go through that area. Part of the agreement is BC Hydro will clear the area of trees. And they don't do that. I don't know why. It's not really germane to the facts. Now, what's the problem with them not clearing the space for BG Checo?
Well, he has, it has to clear the space in order to complete the contract.
Right, but on top of that, they only billed for the amount that presumed the area will be clear. So they have to spend more money than expected in order to perform the contract. So they're going to be out money. So they can sue in contract because the contract said BC Hydro will have cleared the area, breach of a term. But that doesn't really do anything for them because they need to sue in tort, curiously enough, in order to recover their economic loss. All that money they had to put out in order to clear the area, just to perform the contract.
They cannot sue for specific performance, for like PC to clear the area.
How? Because
Because PC like breach the term that they have to clear the area from cheese, so they cannot go to court saying or demanding like a specific performance, so the court like order PC to clear the area.
technically you could. I'm trying to think of it like in another scenario. Like if you have contractors do work for you on your house and you say, I'm going to clear out the hedges, and you don't. They'll clear them out, but you're going to get a bill. It's just more efficient to get the work done. Yeah, than going to court and saying, you didn't do this. And so I think that's the non-legal choice, so to speak, that BG Checo made. So how did the court decide? In terms of the tort contract overlap?
Our news that the court contains a clause that explicitly says that if you don't have the right to sue in tort, there is always a concurrent right to sue.
Right. So, unless it has been expressly taken away.
Yeah. And the fact that there is a clause that deals with the matter, that it's not enough.
Right, and that's the interesting part. Just because there is an express contractual obligation does not exclude tort liability. It depends on how the contract is written, simply put. So this kind of returns us to our discussion of exclusion clauses and gives us a variation on that same concept of courts are a bit more skeptical of exclusion clauses. And so they will scrutinize them a bit more. Here we see another scenario in a very different context, though. So it's an interesting principle that comes about. And the way I think of it is BG Checo kind of confirms to us that in the practice of law, contract and tort overlap a fair bit, especially when we're dealing with commercial parties and big sums of money, simply. I'll give you a minute to reread, I hope. So Beauchamp. I don't know how to pronounce the other guy's name. The Beauchamp, did I give you a summary?
Sobotinsky.
That guy.
Easy story.
Out of curiosity, do most of you type your exam? I can tell you're not going to do well. I'm kidding.
Nice, Joe.
I will write this
I appreciate your sense of humor.
I thought most people type.
I didn't type fast enough.
Oh, yeah.
And I'm worried that something happens to my computer and then that's my worry. Yeah, probably I try to get as fast as I'm writing, but I'm worried about I'm not a genius in technology, and I worry that we'll get all the exam.
You can
Something
switch in
not
the
very-
exam.
What?
You can switch in the exam. You can start typing, and if your computer breaks down,
No, but now it's my last exam, I'm going to start now to learn this program. You also write?
In the UK, they handwrite everything. And then they give you this little piece of string to tie your bookmarks
Oh,
together.
really? You even put it down?
They may. It's so aggravating.
I hope you can read.
Yeah, I spend a bit of time sort of deciphering the handwriting, so that it's not like I gloss it over. It makes it difficult to read.
I think it's legible.
So what happened in this case factually?
There was a flood.
I'm feeling book of the Bible started out.
So anyway, they saw the house and after, before the closing, there was a flood which was not informed to the buyers, and they covered up the damage.
Right.
So probably that was also a problem. They didn't realize probably that they should have fixed something in the basement until they had another flood. And then they realized that there was a they had what was the name of this agreement they signed?
An agreement of purchase and sale, APS.
Yeah, there's no, this SPIS.
The seller property
Yes, property
information.
information, yes.
So what was the problem with these?
So they said it was a negligent misrepresentation, not to say, not to inform them about the pre-closure.
Yeah. Pursuant to the seller property information statement. So representation is made, everything is fine through the SPIS, and because there's a continuing obligation, as we saw with and Flanagan, for example, that was not corrected, arguably there was a negligent misrepresentation. Sorry, contractual misrepresentation. And then, how does the APS come into this? Yeah.
So the APS had an entire agreement clause that said that this document constitutes the entire agreement between the parties. And basically, once they signed the second SPIS, the defendants basically said that you should not rely on the SPIS because we already have a document that says this is the entire agreement between us.
Right. So the SPIS is irrelevant.
Yeah, so
We have an entire agreement clause in the APS. And how does the entire agreement clause function then? What does that mean that entire agreement clause?
The entire agreement clause functions retroactively, so it does not extend to the relations of the parties in the future.
Right.
So whatever happened before the time the APS was concluded, that is covered by this entire agreement clause.
And what does that mean? Just to be clear, because I'm not sure everybody will be clear on it. What is an entire agreement clause? So you said everything this is a document in itself. You can only rely on this. This contains all the obligations.
Yeah, it means that if there were any negotiation statements, representations that are not included into the agreement, the parties should not rely on them. So only what's covered in the agreement. This is
right.
This is the agreement.
Offer of acceptance and consideration.
Yeah. But also that this entire agreement clause functions like an exclusion clause in this case, because it says anything afterwards you can't sue for. That's the argument. And you'll see this if you get into commercial contracts. An entire agreement clause can function like an exclusion clause. That it bars any sort of tort action. Because basically it says, well, anything that goes wrong has to be grounded within a breach of this contract, this document. So that's an important factor here, because, as I said, there's a flood after this is all done. So the two issues: did the divisional court err in finding that the entire agreement clause in the APS did not preclude a claim based on representations made in the SBIS? And did the second one, did the divisional court err by concluding that the respondents had made out a claim for damage based on negligent misrepresentation? So, first question: can the buyers sue in tort?
Yes.
Why? And you touched on it already, if you want to repeat it.
Because they said that the APS covered the relations of the parties to the moment the agreement was signed.
So, in this case, the entire agreement clause did not function as an exclusion clause regarding a tort action. The sellers were trying to say, all our obligations are in the contract, anything beyond the contract is excluded by the entire agreement clause. And the Court of Appeal upholds the decision, and the Supreme Court denied leave, that this in fact did not, this being the entire agreement clause of the APS, did not function as an exclusion clause, because the APS only operated to close off any sort of what we've been looking at, oral representations, for example, leading up to the formation of the contract. So, just in case it's not clear, you put an entire agreement clause in a contract as a way of avoiding, or at least limiting, the opportunity for the other side to sue you in tort. For example, a negligent misrepresentation. Because you say, everything that the parties are obliged to do is in this document. And anything beyond it is irrelevant. And both parties sign that. So the entire agreement clause closes off any sort of other action outside of the agreement. And the Court of Appeal says, as you said, that agreement, the APS, only deals with things up until the point that the agreement for purchase and sale is signed. It does not deal with anything that comes after that. That's why the phrase was used, it's retrospective, not prospective. Retrospective in the past, prospective in the future. So the defendants are trying to say that the entire agreement clause operates in a way that is beyond the way in which it should operate. And the Court of Appeal says that's inaccurate, the interpretation by the defendants. Because the APS only deals with everything that happened before the agreement was signed. This flood, which happened afterwards, is not affected by the APS, and in particular, the entire agreement clause. So therefore, Beauchamp can sue in negligent misrepresentation. Why? Because they had the SPIS that said everything's fine when it wasn't. We relied on that. Or did they? And that's the question, the second question. Did the divisional court err by concluding that the respondents had made out a claim for damages based on negligent misrepresentation? And they say yes. Why? Yeah.
They did not indicate that the fourth element of the misrepresentation, they did not prove reasonable reliance to their detriment.
Yeah.
And I think this because they were already obliged by the first contract to buy the property, so the misrepresentation did not have any effect to their, a detrimental effect to their interests.
Yeah, so this is kind of odd if you think about it. Negligent misrepresentation, we talked about the criteria, and that last point, what they call the fourth point, we haven't dealt with it in terms of numbers, but the reliance, the court is saying, well, Beauchamp fails on that, because you already had an agreement to buy the property. You were contractually obliged to buy the property. This flood and the misrepresentation had no effect on you entering into that contract. Yeah.
If act for the claimer, can I frame the action as that, I have already bind to enter into the contract, but because my reliance on your statements, I didn't take any action to take insurance policies, and the consequential. This is the so the property don't have to be covered. Don't have insurance coverage for the property.
I don't understand the question.
It means that your reliance could for different purpose. So you rely on this to buy the property, or you rely on this for your other decisions, like whether you will take a insurance policy.
Okay, but it happened after the contract was signed.
Yeah, but before, so the reliance is not for the purpose of claiming any damage on entering into the contract, but for your didn't take any insurance policies. Can such claim succeed?
I don't see how that would be reasonable.
Because you made a representation to me that there is no fraud, so I didn't take any policy.
Yeah, but like when you agree to purchase a property, I don't remember the details, but presumably there's some sort of insurance dealt with there. So if you don't take it out when you had the option to, or you, under the contract, you were supposed to, you can't say you didn't take it out because you told me everything was fine. The nature of insurance is you take it out in case something goes wrong, not because something goes wrong. So what we have here, sort of to sum up, is things get kind of complicated when we have the contract tort overlap. And what I suggest is really separate out the facts when you apply the law. And here, I think it is a good illustration of that. We have the contract, we have the entire agreement clause, but it only covers up until a certain point. But just because it is not prospective, the entire agreement clause, does not bar does not mean the plaintiff automatically wins. You still have to make out the elements of the claim. So when we're looking at the classic example that we've seen is an exclusion clause for tort in a contract. If you're successful in saying the exclusion clause doesn't apply, you still have to make out the elements of the tort action. So it's a long road, this area of practice. It involves contractual interpretation, contractual arguments, but then going through the full negligence analysis. And in this case, in Beauchamp, the plaintiff fails because they don't make out the elements of the duty of care criteria for negligent misrepresentation. So if this was an exam question, the issue is the duty of care aspect. You should still note the breach, causation, and remoteness aspects. So here you could say, well, if there was a duty of care, it would have been breached, here's why. There would have been causation, but for, and it wasn't too remote. You can do something simple. It may seem like you're doing something irrelevant. The reason why I'm saying you should is to get into the habit of doing that, because you don't know which cases come in with just the duty of care argument. There could be a causation argument. So you go through the whole analysis. And you're being paid by the hour, so what the hell?
So you go through the 5 steps for Ayakubuchi's test for both contract and negligence?
So Queen and Cognos is separate. I think is what you're referring to. Queen and Cognos is a discrete example. What we're looking at here with Beauchamp is you have an exclusion clause that you don't have to go through the exclusion clause analysis because the court says, well, it's retrospective. But then you have to go through the tort, the negligent misrepresentation analysis. For here would be an established duty of care.
Is that because for the contract part, you don't have to show detrimental reliance? I'm just thinking, you have the facts and they're kind of floating around. And when you're going to do on the contract side of things, do you extend the analysis to get into detrimental reliance?
Don't quite follow. Sorry.
I'm asking, so when you get the facts and you're looking at the case, the facts, and you're thinking, is this a question here of a tort matter or a contract matter and the overlap, and how you like to lay out your arguments?
Oh, well, here, so it's sort of an order of operations, right? Like, here, we don't have, does the exclusion clause, is it applicable, sorry, we don't have a Turcon analysis, exclusion clause, because that wasn't relevant. We didn't need to do Turcon, because the entire agreement clause only dealt up to a certain point, and the events in question came afterwards. So the question of whether or not there was an exclusion clause, issue 1, was dealt with more or less factually. So I guess if you want to use Turcon, you can say question 1, does the exclusion clause apply? Answer, no. And you explain why, which was what the Court of Appeal did. Then you go to the tort because you're not barred from bringing a tort claim. Here it's negligent misrepresentation, you go through the applicable test for negligent misrepresentation. So the two, this is sort of a classic example of the overlap of the two. You have the contract issue. Here, it was thankfully kind of a short issue because the clause exclusion did not apply. If it did, then we would go through Turcom. Was it unconscionable or was it contrary to public policy? And then if we conclude, let's say hypothetically, that the exclusion clause or entire agreement clause in this case was excluded for public policy, then we can go to the tort. If you think that the exclusion clause will be upheld for exam purposes, go to the tort anyway. This will be the standard practice in any practice, to do the complete analysis. Then when you go to the client, you say, this is why I don't think you have an argument, if your advice is that way.
So just one quick question. Is it always a slam dunk position that complete agreement clauses are in the bracket of exclusion clause?
No, but often they are used that way. So it's sort of a variation on the exclusion clause.
So the test for material misrepresentation in tort is
The test for...
The test for negligent misrepresentation in tort is Hercules management, right? That's the test.
Yeah. Unless it's a novel, then you use the Imperial Tobacco. So next week, as I said, we'll come with some questions for the Monday session, things to clarify. And we can start into last year's exam, last summer's exam, and continue on Wednesday. But remember, we're up on the 4th floor, where there's no air. And if you didn't sign the attendance, it's not good. Otherwise, have a pretty day.